or whatever. I thought, can you hear me? Oh, that's better. I thought that I would just go through some of the areas where, as campaigners, we see problems other than the ones that you've already raised. I've gone through my list and crossed out the ones we've already spoken about, because that would be a bit tedious. But just before I start doing that, whilst Colin was speaking, I scrabbled around and got some signal on my phone and found the ministerial statement from the 25th of January, which says that, this is the Norman Baker Department for Transport, I have decided that when DLA is replaced by PIP, there should still be a legislative link. That means those people who score 8 points or more in the moving around activity of PIP will be automatically eligible for a blue badge. This activity assesses a person's physical ability to get around, and a score of 8 points or more will be awarded to people who are either unable to walk or who cannot walk further than approximately 50 metres. They chose that because that's as close as they could get to the current automatic entitlement. Colin and I were just speaking to each other about the fact that neither of us have a first idea of how you're ever going to apply that if claimants don't get their points, but we hope that DWP will do something about that before it's too late. So that was the first thing I was going to say. Another thing I will say just now, because I don't want to forget, is there was a bit of discussion earlier, and I don't want to open it up too much because we haven't got a lot of time, but one of the ways in which the criteria have been tested is that they've been tested on a group of about 900 or so existing DLA claimants. So those of you who are saying, well, how do you know how much you're going to save at the end of it? I think part of the answer is that they've been testing different criteria with this smallish group of claimants, most of whom, I'm told, by DWP officials, have more than one disabling condition, and that's enabled them to make some projections about the numbers they expect claiming different components at the two different levels, firstly by 2015 and then more importantly by 2018, when the entire working age cohort of DLA claimants will have been put through the PIP process. I believe it is those projections from that testing which has come up with the answer that about 600,000 people will no longer receive an award, and more than 400,000 fewer people will be receiving the enhanced mobility component than would be receiving the higher rate DLA mobility component if DLA was to continue to exist. I just made a note that that might be helpful for you to know that. One of the things that Colin said was, and I questioned him about it earlier, you may remember, is that at the moment, the necessity to consider whether a claimant can undertake an activity safely to an acceptable standard repeatedly and within a reasonable time period, at the moment that's in guidance. But there are amendment regulations that have been tabled that hopefully will pass into law very soon. We've been assured, that is, campaigners and people who've met with DWP officials have been assured that these qualifying phases will enable the assessor to consider whether undertaking an activity causes pain, fatigue, breathlessness, etc. I've always been a bit sceptical, to be honest, and I've said things like, well, why don't you just say without severe discomfort, as is the term currently used in DLA, but they haven't wanted to buy that one, so I don't know why not. But that's just one area in which we have had concerns. There are basically two aspects of PIP where I have concerns in both areas. One aspect is the criteria, the assessment criteria, and the other aspect is the process, how the claim process will work. In terms of the criteria, we have a very general concern that the criteria are very specific and very restricted. DLA has tended to be open-ended, so you can put on the form any way in which you struggle with all sorts of activities of daily living. PIP is very, very specific and very restrictive, and I can foresee problems relating it to my own situation where people might fail to get sufficient points because they might struggle with a lot of things, but they don't actually struggle with the specific activities that are being measured under PIP. And that's a big concern that I have. For instance, there's no activity covering going to bed, sleeping, or getting up in the morning, which to me seem to be fairly fundamental. Along those lines also, because they're removing the lower care component, they're not having a replacement for the lower rate care component of DLA, people who have just a low level of need are no longer likely to get an award. People whose only difficulty is that they can't make themselves a meal will no longer get an award, and people who need continual supervision may no longer get an award. Sorry, was that a question? It is very difficult to say because of the quite complex process of identifying whether a particular claimant, because we're all completely different, scores under the descriptors and in the activities that are given. But I took this from Disability Rights UK, who issued a press release late this afternoon, and two of the things they highlighted was people with those particular difficulties but no other difficulties. I have heard along the way that there does seem to be a problem with how people who need continual supervision will actually qualify. It is quite complex, the way the assessment works. So all I can say is, this is what we think could be a problem, or is likely to be a problem. Until it starts being rolled out and we see how the assessors are actually applying the criteria, we won't actually know. There is another issue about the criteria, is that certain activities are stated to be, should be related to people with physical impairments, and certain activities are designated to be, to relate to people with, say, cognitive impairments, which is rather restrictive in itself, best illustrated perhaps by the activity about making budgeting decisions, handling money. That's stated to be an activity that is to do with cognitive impairment. But a colleague of mine very quickly came up with the thing, well, you can't really handle money if you're not physically capable of writing a cheque. But that's not included. The way they've made certain activities relevant for physical impairments and certain activities relevant for cognitive impairments or sensory impairments means that you can't take a holistic and practical view of all the different processes that are involved in certain activities. And I've just picked that one out particularly because it didn't take somebody very long to work out that she felt that should apply to her, but she realised it wouldn't, because physically being able to write a cheque is not relevant. In general, we feel that a very high bar is set under PIP that you have to get over to demonstrate you need support in particular activities, which is another aspect of what I said, it's pretty restrictive.
Okay, can I ask one question about mobility and getting around? It seems you're related to flat surfaces. I think maybe that's the point you made about there's nothing that I think in DLA about getting up and down stairs, for example.
There's nothing about going up and down stairs. It's not one of the activities. They say that moving around is considered to be outdoors and should take account of the need to negotiate curbs, but there's nothing specifically about going up and down stairs. Or moving around indoors, that's right. These are all issues that we are concerned about.
Can I ask you a question?
Yeah.
What happens when the next lot get in, the Labour Party, or the Liberal Party, what happens then? Are you back to square one, or they're going to get shot of that lot and bring another lot in?
Absolutely no idea, but don't let's forget that it was Labour who brought in the work capability assessment.
It's all changed there, and they've changed their mind now.
Well, they keep changing as far as I can see. We really don't know. Well, they're always wasting money, aren't they? What I do suspect, though, is that the decision to not reassess anybody with an indefinite award was deliberately postponed until 5 months after the election, so that people losing their cars left, right and centre would be a problem for the next government. They're politicians. They said it was so that they could make sure the process was going okay first. Maybe. Actually, on that point, there is a serious point to that. They have undertaken to do a thorough review of PIP in 2014. And I've made some gently stroppy noises about what I think that review should involve and about what kind of things they should be monitoring in preparation for that review. So, for instance, they can't review how things are working out for people who don't still get the benefit if they don't monitor what happens to people who don't get the benefit. I think it's a meeting in June where we have an opportunity to explore this with DWP officials a bit further. Well, I'll wait anyway for my opportunity. We do consider that there are insufficient points awarded in the assessment for incontinence in particular. Anything to do with continence is it's a very big issue for people, but it doesn't seem to attract very much in the way of points. The biggest issue about the criteria is the 20 metres walking criteria for the enhanced rate. You may remember from Colin's presentation, there are two activities in the mobility part. There's the planning and following a journey and moving around. For anybody who is physically disabled but has no cognitive or sensory impairment and no significant mental health difficulty, the only activity in which you can collect points will be that physically moving around activity. And to get 12 points, you have to be unable to walk reliably, repeatedly, safely, etc., more than 20 metres, which is less than half of the qualifying distance for higher rate mobility DLA. And the major concern about that, of course, is that you need the enhanced rate to get onto the Motability scheme. I have been working very hard with Motability over the last few months and saying to them things like, we know it's not your fault, but does it make an awful lot of sense for somebody's adapted car to be taken away, only for them to need another one as soon as they've won an appeal? I don't know if there's time to show this, but I thought just to break the monotony of my voice, I would just show a video my son made of me using my vehicle. I think I might fall foul of the 20 metres, and my vehicle cost the government Specialised Vehicles Fund a lot of money.
That's if you're honest.
Yeah, you'd hardly dare not... whatever. Don't go there. I don't think...
And I decided to make this video as an example of the damage the government is doing by its reform of disability living allowance. Whilst the visual content demonstrates how my vehicle works, I explain how losing it will affect my life. I've been using a wheelchair for about 17 years because I suffer from disability. I can't walk far without feeling pain, and I also get short of breath very easily, and sometimes I need to use oxygen. Along with many other medications, I take morphine on a long-term basis. The government has decided that under personal independence payment, which will replace disability living allowance, people who can walk more than 20 metres will not be eligible for the Motability scheme. As I still walk in the house, I'm worried I may lose my wheelchair accessible vehicle, which enables me to go out independently or to be driven by someone else. Without my vehicle, it will be difficult or impossible to get to hospital appointments, support my elderly mother and her disabled neighbour, volunteer, speak at meetings, visit family and friends, either locally or elsewhere in the country. In other words, most activities that happen outside my home. As most of the upfront cost of my vehicle was met by a government grant, my question to ministers is this: why waste that money by taking away my vehicle? The government tells us they want us to be independent, support our families and engage in voluntary work, but they seem determined to ensure that we can't.
Right, I'll stop that now, it's the end. As I drive off into the sunset, or whatever. My son made that as a campaigning tool over the New Year weekend. I thought it was quite good, actually. Sorry, it was my voice as well, but it's a bit different seeing it on the screen. So, because of our concern about the 20 metres criteria, our lawyers, just before Easter, issued an application for judicial review of that criteria on behalf of 3 legally aided claimants. And we made that judicial review public today. We don't know whether the High Court is going to allow it to proceed. We'll probably find out relatively soon, I would think. The DWP definitely wants it thrown out because it really mucks up their plans. But we did get the application in a week after the regulations were passed, so I'm not sure we could have done it a lot more quickly than that. 20 metres appeared out of nowhere in the middle of December after all the consultation stages were over. And I know Colin said there was loads of consultation. There was loads of consultation, but after the consultation was over, they reduced the distance criteria by more than half, and then claimed that this was absolutely fine, etc., etc., etc. They said it was making it clearer, and they said it wouldn't make any difference, and our lawyers, our barristers, have advised us that the consultation is likely to be viewed as unlawful, but we'll see what the judge says. So we're doing our best. That is the worst, I think, aspect of the criteria. Most people agree, even if their difficulty isn't walking around, most people agree that is the worst criteria. The government admits there's no evidence behind it, that they virtually pulled it out of the air. It's really very strange. Anyway, I'd better hurry on because I realise I've got about 2 minutes.